reversion application against the procedure to, as it were, potentially remove Chief Justice Gertrude William, chairperson of the 5-member panel. Her Ladyship Justice Professor Henrietta Mensah-Bonsu stated that due to unavoidable reasons, the case had to be adjourned to May 6. Legal Affairs correspondent Latif Idris was in court this morning, and he joins me in this. So Latif, tell us what went down in court today.
Yes, so the case was called as scheduled at 9:30. There were two cases, two for judgment actually. So those two cases were called, and then this one was supposed to be the third. Now, when the justices appeared on the panel, we noticed there were only 4.
Instead of 5.
So amongst ourselves, we started discussing what's going on. And then noticed there were only 4.
Instead of 5.
So amongst ourselves, we started discussing what's going on. And then prior to that, Dr. Aine, who is the Attorney General, and his predecessor, Godfrey Adjournment, had been called in chambers by the justices. We do not know what they went in there to discuss, but just as they stepped out of that meeting, news started making rounds within the Supreme Court building that one of the justices is unavailable, and so potentially we could have this case being adjourned at a future date. And so when they finally came and sat, Her Ladyship Justice Henrietta Mensah-Bonsu quickly took over and mentioned that we have had a discussion in chambers. And so that is what I want to put to you in open court. So she made it clear that we've had some problems, and I'm trying to quote exactly what she said. We've had some problems, and so due to unavoidable reasons, this case has to be adjourned. And so she said that, and both lawyers, Godfrey Adjournment and Dr. Aine, both accepted it and said she proposed May the 6th. We can speculate and say maybe they had agreed on these dates when they went into chambers. And so that was what happened. And so the case itself was not called at all. And we spoke to Dr. Aine. If you recall, last week when the case was adjourned, Dr. Aine was not in court, but Godfrey Adjournment was in court. And he was speaking to newsmen, and he mentioned the fact that because the case is currently at the Supreme Court, processes have been filed at the Supreme Court, he expects the president to suspend his consultation process
onto the determination of the case
of the case at the court. Today, I asked Dr. Aine what he makes of that position the former Attorney General holds, that all processes, consultation procedure must be halted for the president until a final determination of the Supreme Court on this particular matter. And this is what Dr. Aine had to say.
To hear the case, it's not mine to make, all right? And the reason why we were absent at the last agenda date was because we organized a training far ahead of the date that was given to us by the court. And the training was for all state attorneys, all right, by the ECOWAS Court of Justice. So they were being trained on the procedures and rules of the ECOWAS Court of Justice. And because of that, I was deeply involved in the training. My deputy was deeply involved in the training. The ECOWAS delegation that was doing the training was here in Accra. And we just asked for a date. Lawyers ask for this all the time when they are constrained and cannot be available in court. So for you to interpret that to mean that we are not willing, to go along with this process is totally unacceptable.
So Latif is still here with me. So Latif, a lot went on after the in-camera meeting between the Attorney General and the former Attorney General, and then the outcome of their deliberation with the presiding judge over this matter.
Yeah.
But you spoke to him on other matters.
Yes, if you also recall, Godfrey Adame had also made the case that, first of all, because the case is at the Supreme Court, the president must hold on. He also accused the Attorney General of not showing up in court because he doesn't want the case to be heard. Again, Dr. Ayine made the case that whether the case is heard at the Supreme Court or otherwise doesn't lie within his purview, and that he doesn't have any control over such decision.
I haven't spoken with the president yet, and I cannot give any definitive answer to the question whether the consultation will continue.
What's your advice to him because of the pendency?
The president and the republic are my clients. I will not advise my client publicly.
The last time the former Attorney General spoke, he said he expects nothing but the president to hold on the processes. Is that what is happening?
Well, he has filed an application in court. The court is here to make an order. So if he says that the president must hold on, is he saying that the court has already granted an order in respect of which the president, must not continue the process, right? First of all, he has to understand that this is the performance of a constitutional duty, all right? And the law is very clear that you cannot enjoin the performance of a constitutional public obligation. And so, for me, I don't see the point that he's trying to make by saying that the president must hold on to the process of consultation.
His argument is that because of what is happening here at the Supreme Court, the president ought to hold on.
Well, that is why I have said the president is performing a constitutional duty, and the law is very clear that you cannot enjoin the performance of a public obligation.
What do you make of today's adjournment? The adjournment.
No, the adjournment is to May 6th. So, because one of the panel members was not, was unavoidably absent, and so the court has adjourned it to the 6th of May.
So we'll have to wait till May 6th before we'll get to understand how long this case will travel. But again, you may recall there are 3 petitions to the president. These petitions were forwarded to the Council of State. The Council of State made their own judgment on it. The petition went back to the presidency, then went to the Chief Justice for her to respond within 10 days. Her response has come in. And then it's unclear whether there is a case for her to answer, pending the advice that the Council of State will provide. Meanwhile, the minority in Parliament has weighed in on the petition seeking the removal of the Chief Justice from the office. Speaking at a news conference today, legal counsel to the minority caucus, John Darkman, described the petitions as significant setback to Ghana's democratic progress. He also described some of the claims captured in the petition as ridiculous and a ruse to get the president to suspend the Chief Justice.
Of the above, that we see that the spurious petition for the removal of the CJ as a serious setback to our democratic journey. We are aware of the petition. The purpose of the petition we have gathered is to malign the head of the judiciary, orchestrate her removal, and thereby silencing the judiciary, and finally to exert control. We are aware of the plans, and here I want to repeat again. We are aware of plans being hatched to invoke Article 14610A to suspend the CJ, to appoint somebody who is a known sympathizer of the current NDC government to act as the Chief Justice of the Republic.
Right now, let's focus on main discussion.
I have many friends. Let me take some money from the NDC. Spio Gabra is my friend. Guzitano used to be my friend. I say used to be because I've not seen him in a while and I don't know, but yeah, used to be. So Guzitano becomes president. Oh, no. Asedu Nketia, you all know Asedu is my friend. Asedu Nketia becomes president. Then I go to him, General. Charlie, wait there, let's put bygones at bygones. So me here be people. I say, customer, we are bad boy. I say, Judge, Chief Justice, say me case be na me yo Kumasi na say case. Oh no, transfer judge na. I didn't acquire basasa. Say, oh, what's that? Be na that pankro no. Oh, any for petition, but you know. That's this. It looks like that's what is happening. It looks like that's what is happening. That your case has been transferred. If you take from Philip Archer, 1992, and bring Chief Justice who have transferred cases, you find numerous of them because that is their work. That is their job. They do that all the time. The Constitution has given them the power so to do. And then Daniel Forrest is bringing an application to the president because the Chief Justice has been transferring judges that have to do with his case. Really? Daniel Forrest, come again. Why? Now we're there. Well, again, we are not the Council of States. We don't know. But this is the fact. So this is why Justice Mirku found himself in the EcoBank matter. Then there's another one. Daniel Ofori versus EcoBank. Transfer from Justice Lodo to Justice Mirku. EcoBank petitioned for the case to be heard by the same judge to avoid multiplicity of suits pursuant to Order 1, Rule 1, Clause 2 of CI 47, which provides that matters in dispute must be determined and multiplicity of proceedings must be avoided. So because Mirku was handling this one, it made sense that Mirku will handle all pursuant to Order 1, Rule 1, 2 of CI 47. Daniel Ofori has lawyers. Didn't they tell him this? Didn't they tell him? But I'm sure they didn't think that the petition will come out public for everybody, all of us non-entities to see it and be talking about it on that your TV. As they tell me, you go and sit on that your TV and you are fooling. Yeah, they didn't think that non-entities will see it and go and sit on that their TV and be fooling. But now here it is. The first year law student, the ordinary Ghanaian child, the ordinary Ghanaian university student, the Ghanaian SS student, if he's paying attention, will wonder, what is this about? Is Ghana about Daniel Ofori? Ghana is about Daniel Ofori. Yeah, Daniel Ofori may be a good taxpayer. Yes, he pays more tax than most of us. But that doesn't mean Ghana is about him. It's not about him. The 1992 Constitution is not about Daniel Ofori. It's not about him. The 1992 Constitution is not about anybody. It's about, if you read the first line, sovereignty relies in the people of Ghana. That is what is in the Constitution. It's not about Daniel Ofori and Dominic Ayini and Justice Remsai. It's not about them. It's not about Akufo-Addo. It's not about J.A. Kufuor. It's not about Dr. Baumia. It's about sovereignty relies in the people of Ghana who have given themselves this Constitution. It's not about Daniel Ofori. Daniel Ofori cannot use constitutional processes to sacrifice, to satisfy his whims and caprices. No way. It shouldn't be. Nobody should be allowed to do that because the Constitution is about the people of Ghana. Well, this is another one. The petitioner alleges that the CJ sat on a panel for a review of the Supreme Court decision when she, the CJ, was a judge that sat on the same matter before the Court of Appeal. Daniel Ofori's final allegation is that Justice Tokonu sat on a Supreme Court case involving him, but that Justice Tokonu has sat on the same case when he was at the Court of Appeal. Whilst that is not true, and we're going to show that's not true, there's nothing wrong with that. Unless you can show that during the Court of Appeal case, Justice Tokonu told you, made prejudicial comments against you, against your person, and therefore has demonstrated that she is prejudiced against you as an individual. In that case, there are processes in the court for you to file. We have seen that happen. You can file an action for Justice Tokonu to recuse herself from the Supreme Court bench on the basis of this and this and that. We have learned that since Salah and Attorney General in 1969, Daniel Ofori. Abeyo, Justice Anija against famous ruling in whether there is bias or not against Adade in the 1969 Salah and Attorney General matter. That is where the Supreme Court settled these things. 69, I wasn't born. Now, you are coming back in 2025, oblivious of what the Supreme Court has long settled, that the judge was biased against you or sat on a Court of Appeal case and sat on it. You didn't file an action before that Supreme Court to say that Justice Tokonu sitting here should go away because this and this is what she's done. So the court has opportunity to look at it and either to agree with you or to disagree with you. You didn't say anything. The case went on. You heard Justice Tokono's ruling, and then you come and now say that President Mahama should remove her because you, Daniel Ofori, you are not happy with the way that she does her work. Daniel Ofori is in the Constitution. Is his name somewhere in the Constitution? Anyway, this is the fact. The case he sat on involved Databank, Danotel, and Daniel Ofori, and hence was a different case from what was before the bench in the case of EcoBank versus Daniel Ofori. Since then, she has not sat on any case involving Daniel Ofori. But this is it. This is the case he sat on. Daniel Ofori has plenty cases. So Daniel Ofori is a powerful, wealthy man who doubles in the stock exchange a lot, who is very powerful and wealthy, who has powerful lawyers like Chachuchi Kata behind him, and who is unhappy with what they consider a small little Araba. That's what they see here as. The learned Chief Justice, who has served 30-something years at the bar, has been one of the longest serving judges from the Superior Court of Judicature, is responsible for doing so much for our commercial court, writing rules here and there. They consider her a small little Araba. That small little girl, that small girl. That's what Daniel Ofori, that's why they sit in their living rooms and they take champagne and they look at the coat of arms and say, we are in power. Take Araba away. That small little Araba. You clear off. You think that's how the Constitution works, like you came to meet it? If that's how the Constitution was, like 2024 election will come and meet it for you to win and for you to come and call somebody small Araba. I see. anyway, yes. So that ends the first one. Now, viewers, something interesting is happening. This is a different story. Related, though. Just as we're coming into the studio, we were told by our sources, reliable, that 2 new petitions have been sent to the president against Justice Tokono. We said, wow, 2 new petitions, 2 have gone to the president against Justice Tokono. Whilst there's no limit to how many petitions can go to the president against a chief justice, we need to recognize that there's something going on. 3 petitions are pending now. The petition that the government was told that you cannot go ahead with these petitions without showing it to her. That was a major issue. And then they did. And they've seen that having done so with the injunction and all that, it may create a problem. This issue of you didn't give it to her can create a problem. So let's formulate 2 new petitions. In fact, in the 3 petitions, one of the matters that was addressed had already been addressed in the Akufo-Addo petition. This issue of she empaneled judges or she's recommended judges and all those things. It was addressed in the Akufo-Addo petition, but they repeated it. And I don't know whether the prima facie is going to cancel it to say that this has already been addressed. So I don't know whether they have new matters for new petitions or that is the same old matter. But quite clearly, there's an unseen hand that appears to be gathering and governing this process.